patent laws that doesn't really work for people, and there is a lot of imbalance in how the law it's applied. So we normally have much more use of what we call TRIPS plus provisions, or provisions that maximize patent rights for IP holders, and a very underuse of the public health flexibilities. That's a reality in many countries, and Brazil is no different. So we have seen, for example, the most used provisions of the Brazil patent law have been patent term extensions, which means giving more extra periods of monopoly to pharmaceutical companies, and the pipeline mechanism, that was something that was created basically only in Brazil, in which Brazil, in the beginning of its patent system, revalidated patents that were granted in other countries without even examining them. So it was totally unconstitutional. By the other hand, when we talk about compulsory licenses, for example, that is a public health tool, Brazil has used only once. And around 2014 and 2015, we also pushed for a major reform in the patent law, trying to have more flexibilities, or expand the scope of flexibilities that we have in Brazil. But these efforts were always derailed and blocked by pharma somehow. We made some progress, but they never went to the last mile. But during the context of COVID, things started to change. And COVID-19 brought this sense of urgency that we applied in our advocacy to try to make sure that our long-term attempts to reform Brazil's patent law were getting somewhere now during this moment where everybody was looking to the health budget, to the health constraints during an emergency, and the pressure over the public health system. So all those topics helped us to connect the dots with the IP law discussions. And for example, we saw finally the trial of one of the unconstitutionality actions around the patent term extensions. And the result is impressive. We are still discussing the benefits of this decision, but the Supreme Court decided that patent term extensions are unconstitutional. And in the pharmaceutical sector, this means that more than 3,000 patents have been revoked immediately because they were already in this extension period. Another 2,600 patents will lose this benefit of extension. It's a benefit that would happen in the coming 1 or 2 years, but they will not have that. So for drugs like pedaquilin, for example, for tuberculosis, instead of Brazil having a monopoly until 2028, it will be only until 2023, like many other countries. The same for HIV drugs, diabetes drugs. So it's a major winning for the sustainability of the public health system in Brazil. Public institutions are not bounded anymore by the obligation to protect undisclosed information in those particular situations. So that's basically the focus now also of the vetoes by the president. They have removed these bits of the text, so really leaving companies to have no obligations at all in terms of knowledge sharing. So we are fighting to get back this text now in the parliament, because the final word is with the parliament, and we can maybe recover this ground that was lost during the presidential sanction. But the good point is that the last bit, the fact that regulatory agencies and government authorities that have technical dossiers, they can share what they have with alternative producers. And this is already a law. This was passed, that's why it's in yellow. So there is no discussion anymore on that last point. So that's a winning. Of course, we want also to put obligations on companies. The public ownership of the flexibilities. This flexibility should not be necessarily in the hands, under the control of governments to decide when they use, when they don't use. So we need to create this mechanism to make sure people can activate all range of flexibilities when there is a public health need. And finally, we hear a lot about not touching patents because this can harm the whole innovation ecosystem. But at the same time, we are seeing our health systems go bankrupt or going into huge debts to finance the response to COVID, to buy these very expensive vaccines and drugs. So I think we should reverse the discussion and really connect the flexibilities to the protection of the health systems, because we heard a lot about the protection of patents and innovators, but much less about the protection of health systems. Thank you.